Just be seated in the back of the room. We ask that you please turn your cell phones off or turn them to silent, please, before the session begins. POSSAP and PAMLE are approved Act 48 and social work credit providers. In order for you to receive credit for this session, participants must be present for the entire session. Please see a POSSAP or PAMLE official to scan the QR code on your ID badge at the conclusion of the session to confirm your attendance. We'll be at the side doors and the door in the back of the room when you're leaving to go ahead and take care of that for you. Your session and conference surveys are available electronically. Please visit the POSSAP or the PAMLE website at the conclusion of your session in following the conference to complete these surveys. According to the Act 48 and social work guidelines, you must complete a survey for each session that you've attended within 5 days of completing the session. Also within 5 days of completing the conference to receive that credit. This will also assist our speakers in future conference planning. At this time, I would like to introduce Erin Gilsbaugh, as she is here to present to us today. Thank you, and I hope that you enjoy the session.
Thank you. All right, let's try this here. I'm fairly loud anyway, so I don't know if I need it or not, but. Hello, can you hear me? Can you hear me? Okay. All right. So the microphone is for the camera, not for you guys. So anyway, I still have. I apparently am of the age that skinned knees do not heal for weeks on end. All right. So today we're going to talk about two topics. We're going to talk about transgender students, and we're going to talk about truancy. They're not in any way related. I'm just the lawyer, and there's a lot going on in the law on both topics, so we're going to actually take a little break in between. I'm going to start with transgender, and I want to give you some background of the law first, but then I also want to take questions, because I know there are a lot of questions on this particular area of the law. She should be coming around with two handouts. You're going to get one plastic one and one paper one. And I will tell you how to get some really great resources on transgender once we get started. For those of you who do not know me, I see a lot of familiar faces, but for those of you who don't know me, my name's Erin Gilsbaugh. I am an education law attorney. I have been practicing school law for a little over 12 years now, and I recently, as of December, stopped full-time practice, and I started an organization called EdLaw Interactive, where I am focusing exclusively on trainings, and we do some web-based trainings. We have a webinar series coming up, but also live trainings. So it's exciting for me because as an attorney, it's much more preferable to be on the teaching end of things because nobody likes to see you when you're their attorney. They like you, they appreciate you, but they don't want you there. So it's kind of nice because now people always want me, and I do not strike fear into people's hearts when I go into their schools. So that's kind of fun and new. Just to give you a little bit of background about myself, I am a former high school teacher. I wasn't very good at it, but I do appreciate everybody now who is. I taught high school for 3 years, and then I went to law school. I worked for PDE's Office of Chief Counsel for 2.5 years. Then I went immediately into private practice. This is, again, it's, don't add up those years because you're going to be, anyway, nobody do the math. But, you know, this year I am I'm doing, as I said, a lot of training, but I also do a lot of work with the Pennsylvania School Boards Association. I'm the president of their Solicitors Association, and I am also on the board of directors of NSBA's Council of School Attorneys, and I do a lot of training for the Council of School Attorneys. So some of the stuff today is national in scope. And much of it is state law specific. So I'll talk a little bit about the differences and you know, why the state law kind of poses a little bit of a challenge, you know, for educators when you're trying to find information, just generally. And that'll be more when we talk about the truancy, when we get to that truancy part. All right, so I got to give somebody an assignment who has a watch. Can you tell me when it is 5 till? And that's when we're going to take a break, and then we'll start talking about truancy because I want to make sure that we give them equal time. But again, ask questions as they come up. I like questions. I like it to be you know, much more interactive, and I have prizes. So if you have a super good question or a comment or something really impressive, I promise in a room this big I won't throw them at you because they are hard and sharp, but we'll figure it out. I don't have my tripping pants, so hopefully I'll make it back there okay. All right, so let's start with the transgender issue. The transgender issue is, you know, for those of us who have been practicing in school law, you know, it's a giant stalemate. There is nothing going on. We were really excited because in January, the Supreme Court was about to hear a 7th Circuit case. And as it happens with all these big transgender cases, they settle because nobody wants to make the wrong law. Lawyers are like that. You know, when it gets to a certain point, you have to remember that case law, especially in the federal court, but any case law is precedent. If there is any clarification on the statutes or constitutional language that's necessary, the courts make those clarifications, and the higher up you go in the court system, the more binding it is on more people. So we're in the 3rd Circuit in the federal court system, and at the very beginning, you have, like, you know, for students with disabilities, there may be like a due process level. But the first level of federal court in our circuit are the district courts. So we have the Western District in Western Pennsylvania. We've got the Middle District, which is a super weird line because it actually, it turns and it goes up all the way into the Poconos. And Scranton is in the Middle District, so it's a weird boundary there because of Philadelphia and how big it is. But Philadelphia and that part of the southern eastern part of the U.S. is in the Eastern District. And then once those cases get appealed, they go up to the next level. So when a case is decided here, where are we? We're in the Middle District. So if a case is decided in the Middle District, it's only binding on the Middle District. Even if they're making a decision about federal law like Title IX, which is the big fight over the transgender rights. So any decision that happens only impacts officially and formally the jurisdiction that it's in. So as it gets appealed, if a case gets appealed to the Third Circuit, the decision that's made in the Third Circuit is binding on everybody in the Third Circuit. That's us and New Jersey and I think part of Delaware, but I could be wrong about that. So it's a much broader spectrum. And then if, like that Seventh Circuit case that just got settled, if we have a case that goes all the way up to the US Supreme Court, that's when it gets universally binding over everybody in America. And the Supreme Court takes cases, they like to take cases where you've got multiple circuits that are deciding very different things. So many of you may be familiar with the Andrew F. case about FAPE and what is FAPE and what's the what's the minimum standard for a free appropriate public education in special ed. Well, in the Third Circuit, we were pretty close to what they said in Andrew F. We used to say it's a meaningful educational benefit. In the 10th Circuit, where that case came out of, they decided that FAPE is something more than de minimis, or more than nothing, more than a tiny little bit. So that's a huge difference when we're talking about meaningful benefit or something more than nothing. That's where the US Supreme Court tends to get involved to settle what we call a split in the circuits. Right now, there is it's all over the map in terms of the transgender law. I'm going to walk you through some of the Pennsylvania law, but I think most of what we are faced with in this climate is figuring out how to balance whatever comes, because I'm telling you right now, I'm going to take you through the law, but you're going to be very unsatisfied at the end of that because there are no answers. Not yet, anyway. And we were kind of hoping that Seventh Circuit would do it for us, but they did not. So, all right, so let's go through. Now, here is my sort of lighthearted summary of the arguments. This is what's going on. This is the basic gist of the legal question, right? All right, so we have all of the initial strife was over the Federal Department of Education's guidance on transgender students. And that guidance that came out under the Obama administration, it took it for granted that transgender students and transgender status falls under Title IX. And so when we have that, that discussion, the question is, Title IX obviously protects against discrimination on gender basis. And so the federal government at the time was sort of just making the broad assumption that, okay, we know that gender identity is related to gender, so we're going to say that it's protected under Title IX. And so that's where we had the big issue, because when the new administration came in, they made what is, essentially a very, text-based legal argument saying, look, Title IX is sex. It specifically says sex. It does not say gender. It doesn't say gender identity. So that's where, the federal government then stepped back and said, no, we're going to interpret it the way it's written. We're going to interpret it as sex. Now, without the Supreme Court giving us guidance, it wouldn't be the first time that we have something interpreted differently than its plain language. So it's not impossible, certainly, to say that that is going to be interpreted that way eventually. But for right now, what the guidance is now saying is, no, we're going to back off of that old Obama position because we are going to interpret it in that black letter context of sex, not gender identity, and allow the states to make that differentiation. And that's typically how it works. If there is a right under a federal statute or a constitutional right, everybody has to abide by. Everybody in the United States has to abide by those constitutional rights, but states can give more protections. So at any given time, and you've probably heard some of the states that are having a lot of discussions, some are passing laws one way or the other. States can certainly solve this problem. They can resolve the issue, but those are then the cases that are going to get appealed because the states cannot give fewer rights than the federal government does. So if the state would say, look, transgender is, if the state would have the argument that transgender means, Title IX protects sex, not gender identity, that's an appealable issue. That's a legally arguable issue because a state doesn't have the right to take away a federal right under Title IX or any other case. So that's essentially what's happening now. We've got two interpretations. They're both viable. One's a plain language and one's looking at the rights as a whole and how they've historically been given out. How they've historically been viewed. And at any point, Congress could step in and help out if it wanted to clarify. But in terms of where we are now, we're stuck in this weird limbo of nobody wanting to make a move, because if you give in terms of the federal rights, and I'll talk about some specific cases in a little bit. But everybody's afraid because it's viable on either side. You could lose if you grant transgender rights. You could lose if you don't. We don't know where the law is going. Now, one case that did come up, and I'll talk about it in a second. There was a case that came up here in Pennsylvania dealing with the non-transgender students' rights to have privacy in their bathrooms. So it basically was sort of the reverse action, and it didn't go very far. So I'll talk a little bit about that one. Again, that's not to say that other ones in other places in the country, but this one happened to be in Boyertown, and the argument didn't go very far. I think the court dismissed it fairly early in the game. All right, so what happened again is we have what are called Dear Colleague letters, and that's where the guidance is coming from. The Obama administration Dear Colleague letter was extraordinarily clear that it covered, Title IX covered transgender students. And then there was another Dear Colleague letter that came out under the Trump administration that said, whoa, let's walk it back. We're no longer taking that position. So because they did that, a lot of the federal court cases got the rug wiped out from under them, because the issue in the court cases was, look, there's this guidance that gives me a right, and my school is telling me I don't have a right. So they're suing the school based on the federal government's interpretation. And there were a lot of cases throughout the US that were based on that legal argument. When the Trump administration pulled that Dear Colleague letter from the Obama administration, all of those cases became moot because there wasn't that same legal argument. Now, that's not to say that we're not going to see transgender cases. We certainly do, because now it's just a case based on Title IX in and of itself. but a lot of them were based on that Dear Colleague letter. And so a lot of the, there was a, right about the time when that Dear Colleague letter got pulled, there was a case that, was up at, was going to go before the Supreme Court and ended up not, because the case was then moot, because it was based on that federal interpretations. So let's take a look at some of these cases. We'll look at, there are 4 important ones in Pennsylvania anyway. And just so you know, I didn't give you handouts on this because you don't need handouts on this. I do have a copy of it, and I'll have it up here if anybody wants to see it. But PSBA last month, if you just Google PSBA 2018 transgender, they put out a really solid analysis of all of the legal cases, and they go through all of the different transgender cases. They focus primarily on Pennsylvania, but they also look nationwide. So if you look at PSBA, it's the Pennsylvania School Boards Association, and Transgender 2018 update or something along that line, it will be the first one. Like, if you just do PA transgender update, it'll come up. It's a really, really great resource, and it goes into detail. It gives you the citations for all the cases that I'm going to be talking about, and it also provides you with links for them, and it talks about a lot more cases than we're going to have time to cover today. So I do encourage you to have that on hand so that you have a really good idea of what the laws are, what the rights are. And again, we're going to cover our status here in Pennsylvania, and I'll certainly answer. I want to leave some time for questions so that we can answer some specific student-based questions, but that is a phenomenal resource, so I highly encourage you to get that. I think when you print it out, it's 10 or 11 pages, so I mean, it's hefty. It's not a small thing, but it's a great resource if you're interested in this area of law and you want to learn a little bit more about it. All right, so let's take some of these cases and look at their implications. All right, so Gigi was and we're all of these cases are, well, most of them I should say, are dealing with transgender students' access to facilities, mostly bathrooms, sometimes locker rooms, changing rooms, that sort of thing. In this case, the school was requiring the students to use an alternative, a third-party alternative. Now, historically, if you look back, this is not the kind of issue that attorneys want to talk to clients about, because truly, in some cases, it's been very clear that if you don't allow them a separate bathroom, you're going to be in trouble. In other cases, if that is what they don't want, because they don't want to be singled out and separately identified, if you do, you're going to be in big trouble. In this case, the Fourth Circuit agreed that the language was vague in the policy, but in the case they were relying on the U.S. versus Doe. And then when the U.S. Department of Education rescinded its guidance, the Supreme Court sent that one back to the Fourth Circuit. So that's the one we lost. That was truly on the cusp of going to the Supreme Court to give us once and for all to tell us how this works. But as we go through here and we talk about the different cases, what you're going to find, the pattern that you're going to find is that it's very much based on the student's preference. So if the student is uncomfortable with the third-party bathroom, that's where the liability may be. So if somebody comes to me and says a student wants to use the third-party bathroom, am I going to get in trouble? Probably not if the student is looking to use that separate bathroom. If somebody comes to me and phrases the question differently, is there legal liability if we have transgender students use the third-party bathrooms? the answer is very different. Yes, there's probably a good chance that there's legal liability, and we're not, as attorneys, we're not just looking at the outcome of cases. We're looking at the potential for lawsuits, because it's the lawsuits that are expensive. Even if you win them, they are expensive. So when we look at it from a legal perspective, we are taking all the cases that exist and we are figuring out, okay, it's almost like a really bad probability math problem, you know what I mean? By people who don't know math, because lawyers do not know math. But we look at it generally in the sense of fact patterns, and that's what law is. Law is just a series of fact patterns trying to figure out which one falls closest to your fact pattern and how would that work. I'll give you a really good example of a client question that I think kind of raised the issue. I could not have phrased the issue better myself if I tried than the situation that she brought up. Unfortunately, I also couldn't phrase any answers for her, but here's what happened. They had a transgender student who was a female transitioning to be male. So it was a fairly recent thing. So it was a high school student, and all of his friends knew him as a girl. So we're not talking about like a transfer student or somebody who's, this has been going on for a while. The student was in the marching band, and they were going to Florida, and they had 4 kids to a room, and this was a transgender male, formerly female, transgender male, and the district as well as the parents, both of the other students and that student, were concerned. So as you move forward with questions like that, now we've got something new in the mix. Now we've got student rights, parent rights, because the parents, until the child's 18, are primarily the ones responsible for filing the lawsuit. But that's not to say that they're not going, the student isn't going to find the ACLU or another organization that's going to be able to take his case on behalf of him. And so now you've got a very big tangle of, a circumstance where you have to be deferential, but you're not really sure who to be deferential to. So I think what ended up happening, and by and large, the solutions here are not going to be technical. The solutions are what you guys do. They're SAP solutions. They're let's sit down in a room and talk about this really complex issue. And you don't have to get into all the political stuff about it. You're looking at the people in the room, the child and the child's dignity, and you're trying to figure out what is the best solution here, because we've got some challenges. And a lot of times, this, the challenges are with the parents as well. Maybe one parent is in favor and one parent is very much against the child's transition in and of itself. So the solutions are not in the law. The solutions are in the process. The solutions are in coming up with something that is going to work for everybody and keep everybody safe. And so that's what we're trying to do. And so it is in the way that you approach it. And a lot of do I have any special ed people in here by any chance? So a lot of if you work in any honestly any SAP position, you guys deal with this, but the way that you answer the question or the way you ask a question can instantly set something off or make something better. You know what I mean? It's all about diffusing a very tense situation, because from a legal perspective, there aren't definitive answers. And from a child-centered perspective, there certainly aren't definitive answers. It is something that you have to work with those, the family members and with the student. You cannot decide this kind of stuff in a vacuum. Many schools have tried to do that. Many schools are still trying to do that. They're still trying to pass very specific policies on this is how we do it, this is how we don't do it. The best thing to do, especially since we're in such legal limbo, is to have the policy be the process. The policy is coming together and meeting with all the stakeholders involved. And I don't mean the public or anybody like that. I mean the parents, the student, the faculty member who might be having to deal with, in terms of the bus trip, maybe that band director, whoever it would be. The guidance counselor is always a good person, usually. Do I have guidance counselors in here? I'm sure I have guidance counselors. You guys are like expert diffusers, right? It's kind of like you have honed the diffusing skill by now. And so having that conversation, because we're finding out here that if it's forced and if it's a predetermined solution, it's going to end up in court, and then it's going to bounce all around. This one went all the way up to the Supreme Court, got its feet wiped out from under it. Now it's back, well, I don't know what it is now, but it got sent back to the Fourth Circuit. That's a lot of money. That's a really big amount of money that schools just don't have in this day and age. So fighting it is not necessarily the way to go. Again, if you can't come up with a solution that works for everybody, you may have to fight it. If you have a school board that feels feels strongly a particular way, so I understand that there are going to be situations that are going to be out of the control of, your team. But I am telling you definitively, with absolute certainty, that the way that you handle those requests and the way that you approach the situation and the way that you explain the concerns are going to have a huge impact on what happens to that case. There's a question?
So would you say then almost doing administrative guidelines that have procedures kind of written in it, or like just a guideline, is way better than doing a policy for the whole district or something along those lines?
You can have a policy, but rather than having the policy take a black or a white issue and make it, the policy can set forth the process. And if that's the way that it's done, and honestly, that's the way it has to be done. And when you're looking at it from a child-centered perspective, you have to consider that part of it. So, again, I know schools don't have a huge amount of influence. Well, sometimes, it depends on your administration and your board. But some boards like to make their policy and they make them and it's done, and then the school has to implement it. But if you are able to have any say or input in that, again, staying away from the black and white, this is what we're going to do in every transgender case. You can do that, but that's what's going to cause the problems. A black and a white approach for all students in all cases, when the law is so uncertain, is just not a great legal bet right now, because there are so many different ways that it can come down. And I don't care which way the policy is deciding. It's not a fixed issue right now. So having and making sure that it's dealt with and it's addressed at the level where everybody has hopefully the most comfort. And so some of the things that you can do to help out the process is bring in the people that are, round out your team that's going to be talking about this. If you have somebody who, the student feels really comfortable talking to, bring them in. Maybe it's their favorite teacher or whatnot, somebody they confide in, maybe it's the extracurricular. If you have somebody who has concerns related to safety, something like that, get input from them and hear that part of the discussion. If it's somebody that is, going to be negative in the meeting, you might want to get that, that feedback beforehand in writing so that you have all of the information, you can discuss that. But making sure that the discussions and the decisions happen in a comfortable, non-threatening environment are, a really, really strong way to start the process. And you know that as SAP team members, you know that it's the comfort level of the parents. For those of you who heard me talking last year, remember I told you that you're getting them a little too comfortable on the suicide thing? They shouldn't be all comfortable and thinking you've got it handled. In this situation, you want them to be comfortable. Everybody needs to think, to truly feel that it is the student's best interests at heart, and that we may be talking about other issues that might be important, but regardless of how it ends up, if you have a circumstance where the parent and the student, hopefully both of them at the same time, do still feel, regardless of what happened, that you have their best interests at heart, that you're not trying to, harm them, or you're not trying to be political or whatever it is. Honestly, that's 9/10 of the battle at this point. With any SAP issue, that's the environment you need to establish anyway. So that's the framework. So this is a good place to be talking about this, because you already know how to establish that, that sort of rapport and that sense of, that sense of trust that's going to be so important in some of these cases. Is there another question over here? No.
I just wondered if PSBA had any model policies for transgender students.
I know that they do have some. I don't think they have anything that's, I could be wrong, it's been a while. I think that's something that probably they're allowing each district to do. It's not really something that anybody is getting involved in saying this, you do this or don't do that. But they very well may have a policy like I'm describing that doesn't, it doesn't answer this specific question. It more talks about the process that's going to work. So I'm not sure. Is anybody familiar with if there is like a model out there?
Or some recommendations of school policies to look at.
Does anybody have a school policy right now that addresses it without making it concrete? What does your policy say?
I don't remember. I couldn't read it word for word, but it is more that, like that we'll get everybody together. Exeter Township.
I'm sorry.
Exeter Township.
Exeter Township.
And they posed it more as administrative guidelines than they did as a policy. They wrote it more that way. And it has more of the procedure part of it. They were told, or we were told by the school board at Exeter, that there wasn't any kind of guidance from.
I would be very surprised if, I'm sure there's probably a policy that addresses it, but I'm sure it does not, touch the specific transgender issue. I'm sure it talks more about the process. So, yeah. All right. So. Taking a look at the Minersville case, and the Minersville case was actually just there was a new action in December. So this was the case where this was a transgender female student, and it was another one of the bathroom policies, the bathroom cases. The district in this case, and this is where, like, honestly, guys, it gets you coming and going. In this case, they were permitting gender identity bathroom use, but they didn't have the written policy. And that's what this case was about. The case was about the student felt that it was a right, that it needed to be in black and white, that it needed to be part of that policy. And so the last, there was a motion to dismiss, and then the last thing that happened in this case is that the plaintiffs amended their complaint in December. So this one's ongoing. And again, you know, this stuff can make your head spin, because what we're talking about as a best practice is actively in court right now. The one thing I can say about this particular type of case is that they would have a very difficult time showing that the student was harmed by the lack of policy. So, you know, maybe future students, but not this student, because for this student, you know, she was actually allowed to, she was permitted to use the gender identity bathroom. But again, that case did not get dismissed. There was, I think there were 2 motions to dismiss at this point, and it did not get dismissed. So it's still out there. It's, you know, it's still, it's still going on, and we'll see, you know, how it ends up going. So this Evancho case, this one we came really close to having some, you know, some sort of finality here. In this case, the school refused to permit the gender identity bathroom. This was a transgender female, and the school said absolutely not. And they cited all their reasons, et cetera, et cetera. They actually won the case, and there's a decision that really sets forth all of those arguments, you know, all of the legitimate arguments for that side of it. This, honestly, it's one of those issues where it depends on which brief you read. They both have very legitimate legal arguments. So in this case, the school ended up winning, and then they settled before it got appealed. And as part of the settlement, they allowed the use of the gender identity bathroom. So that confuses everything, because technically on the books, we've got this case that says, yes, schools can decide this. But in the same exact case, they ended up settling and doing the exact opposite. So technically, the case is still valid, and it exists. It's in the Western District of Pennsylvania. And so at least if you live in the Western District of Pennsylvania, you've got some clearly established case law, except not really. It's, you see, like, this is just a murky, muddy mess. Do you see why I'm telling her to keep time on this? Because we could go round and round. All right, and then this Boyertown one, and I'm checking to see if there's an update in Boyertown. Oh, by the way, this is the PSBA document. I use it all the time. There is not an update for the Boyertown one. So August 1st, there was a joint motion for entry of consent order. This is a case where the student sues the school for failing to notify him of the transgender student's use of the locker room. So this is a non-transgender or cisgender student who is suing, this is that case I was talking to you about, suing on the basis of privacy, a privacy argument. And by the way, there initially, I believe, were a lot of, I don't know if they were actually plaintiffs or if there were petitions to the court, but this was not just one student and one parent in Boyertown. This was multiple parents upset because they were not notified that there was a transgender student in the locker room with their children. And so this was the first case that I'm aware of anyway, even nationwide, where we've got the cisgender or the non-transgender students raising privacy claims of their own. Now, this one, there was a preliminary injunction. Let's see, I think, yeah, so it's still, it's still out there, but there were a number of denials of preliminary injunctions. What a preliminary injunction is if there's an ongoing issue, like a locker room issue, where the student is going to continue to be in the bathroom, they will file for a preliminary injunction saying, look, at least until the court case is over, can you say that this transgender student has to use a separate bathroom at least until you decide, court, how this is going to go. And the court decided against that. They denied that preliminary injunction. A lot of people read into that that's the way that they're going to ultimately decide. I don't know that at this point you can read too much into it, other than the court didn't deem it enough of a privacy issue to prevent it from happening during the course of the litigation. So that's where we are on the Boyerton one. And again, it's interesting to see that one, and I know that nationwide people are following that one because there are a lot of parents that are concerned about those types of issues. In this case, again, it was the notice. It was not necessarily the use of the locker room, but it was the lack of notice that they were challenging, saying, look, if my kid wanted to, get undressed somewhere else or in the stall or whatever, there wasn't any notice provided to us. Alternatively, you can see the arguments on the other side of that notice, right? Like, we're going to send notice that somebody, a transgender student, right? Like, you can see all sides of these arguments. And so, again, I think that we just, until the law gets a little bit more settled, we have to just be sensitive to the fact that any one of these cases can happen. You're not going to prevent the cases as a whole. But what really sparks these lawsuits are the relationships. It's that that decision-making process. So we do have a lot of ability to work with that and to prevent a lot of these issues. Yes, question.
It talks about in the POSPA article here, it talks about as long as the injunction is put in place there, because the district already provided all kinds of options for privacy for all students. So probably private changing areas and things like that for all students all the time.
So those are the types of things that, when you look at these different cases, it's not always transgender bathroom or nothing. Like you're saying, there are a lot of different options. A lot of schools don't have those big. Do you remember, maybe I'm dating myself, but we had the giant shower. Everybody was, it's like a prison shower, nobody brought the shank, but you were always nervous. But they don't do that anymore. They don't. You go into a school now, they don't have that kind of stuff, and so that's something that, again, it needs to be part of that conversation, though. And so I don't know anything about Boyertown. I don't know how that discussion was handled, but you can think, again, you professional diffuser people, right? What would you do if a group of angry parents came to a school board meeting and were gonna because they all remember that horrible shower experience, right? They're not thinking of, you would have a meeting. You would say, let's have lunch. I will sponsor. I will buy the hoagies, and we will all sit down and we'll talk about what everybody's concerns are. Again, I'm not saying that's going to solve anything or that would have solved anything. I really don't know, and obviously it probably wouldn't have if they went all the way to court. But it's those types of solutions, the practical, reasonable, let's not freak out people kinds of things, not making judgments on anybody, not judging the parents that are concerned about privacy, not judging the parents that don't want their kid to be called out in front of all the other parents. Just understanding and listening and trying to find a solution that will work for everybody, because in most cases there are solutions that are going to work. In the most challenging cases, I have never had one of my schools say, wow, we really don't know what, at the end of it, once they're at the end of the discussion period, and trust me, the ones that they call me about are not the easy ones. It's the ones where, custodial mom doesn't want it, and dad's like doing, allowing surreptitious hormone therapy behind mom's back, and like that kind of stuff. But even those types of issues, a good discussion of, in those types of cases, school boundaries. Look, we're not going to go into your home. We cannot make comments about home. Let's talk about school. Let's talk about what's going to happen here, and let's not get into all those home issues. You tell me what questions you have for us here at the school, and we'll answer them to the best of our ability, and not having discussions like, only meeting with mom or only meeting with dad, making everybody come in. One thing, if you have, I'm going to open it up for questions in a second, but if you have issues where the parents are having, the parents are at odds with each other about the decision, what I can strongly suggest to you, and by the way, this is not just transgender issues. This is any student, any divorce issue. You know how they hate each other so much? All emails go to both. Because if you do not, and when you get off the phone, you summarize it in an email to both. Because if you don't, you are asking for a subpoena in a child custody case. So just be really careful to be open about the communication. Tell them that beforehand so that they know they're not going to be able to manipulate you, because you felt pulled by these parents before. If you tell them up front, look, whatever you tell me, I'll talk to you, but I will then put it in an email to both parents, because I feel, in my practice, in what I've seen in my, X number of years as a guidance counselor, that's what's best for the child. I want everybody to have all of the information, because you're both important and you're both important to him. And so those types of, workaround solutions will help you. They'll also help you keep you out of custody court. All right, so we're gonna switch topics here in a second. Does anybody have any, has anybody had any tough issues where you did get it resolved in a unique way? Or policy issues, anything like that?
This is more just a side note on the last point you made about parent communication. Parents, we realized that we had a parent in a divorce, bitter, awful divorce, want a custodial arrangement change, and the school was informed, but our tech department, our email system wasn't. So we were still contacting the biological dad.
Okay.
So
Right.
It was more of a kind of a procedural thing, but we kind of caught that too.
Yeah.
A lot of headaches and a lot of.
I bet.
Just a.
Yeah, no, that's great. All right, yes.
We added the ability this year to change their names. So for transgender students that wanted to be called a different name based on the gender identity that they picked, we put kind of a system into place that their parents would sign off on it, and then changed in our school system the name from like Madeline to Mason, or whichever they picked, and the gender this year. And so far, it's really worked out for a lot of our students, and had conversations with the parent, the student, and the teachers on the pronouns that they would like to be used, and that the name was now going to show up different on their roster and in the system, the Skyward system for attendance, and it's working really well. But it was all that. What do you
headache,
want? How do you feel about it? Let us see what we can do. And The only one that we're running into, or the only problem that we've run into so far, but working with the parent, is that we have a gender fluid student that doesn't want really an F or an M. But you have to put one in our system, and you can't leave it blank.
Right.
So that's the only problem that we've run into so far, but it's really worked well, and it's all because of just kind of sitting down and meeting them where they were and really having those conversations.
And I think, you know, again, thinking about it from a very practical perspective, you know, it's not uncommon where we will have a student who wants to be referred to as one gender and the parents that will say absolutely not. You know, and most schools that I deal with have you know, have reached a happy medium where, you know, the parent does, like you're saying, you know, the parent does have the right to sign off on, to change the birth certificate. The PSBA document also gives you information about that new, you know, changing of the birth certificate. But, you know, we have a lot of schools that say, look, until you make that change, you now can change that. But until you make that change, we're going to call it what's on their birth certificate. But that's a different thing. What you have in the formal records is a very different thing than how you're referencing the child on a daily basis. And most schools use the child's preference for that. And you know, I don't know that we've ever had any issues with that. You know, the school will say, okay, parent, if you really don't want it, we're not going to change it on the report card. We're not going to change it in the information. And in fact, we never change the male to female unless we see a birth certificate or medical documentation that shows that it should be changed. That's actually probably you know, that's as close to a legal reality as you can get, because you may not want to be changing that on a fluid. That may have medical implications if somebody comes in, emergency response, whatever it is. But the way that the school addresses the child on a daily basis, that is, you know, almost universally, you know, dealt with in terms of allowing the child to select, you know. And so, again, different schools have different processes and procedures, but rather than saying, hey, at this school, this is how we deal with that, or this is what we do, you don't deal in black and whites like that. You all sit, you know, you all come to the table and you talk about, you know, how that's going to work and what you're going to do for that. All right. There were a couple more hands, but maybe we addressed those. Okay, the little plasticky thing, and I'm sorry, I don't have one. Are there extras of the plasticky thing? Somebody have a pile of them somewhere? There should be. I made like a lot of extra. Here. Okay, this I gave you because this is not just transgender. In fact, until we know whether it's unlawful discrimination or not, it may not be transgender. I don't know. I'm making no comment on that. But what I gave you here are just some, I do a lot of work with policies and procedures. If they're well done, can keep schools really far out of court. And if they're not well done, they can, you know, get a district sued really quickly. So what I have here is I gave you some suggestions on things that you can do, because again, I think one of our biggest problems is the problem of tolerance, and making sure that we have an environment within the school that regardless of what's going on outside of the school, every student feels valued. And I'll tell you what, I did not actually create this chart. I created last year when I was doing the Education Law Association's conference on immigration. It's the same concepts though. The idea of making all students feel welcome, feel encouraged, but not just making the students themselves feel welcome, but teaching them how to welcome each other. And so there are just some suggestions here, starting with making sure that everybody understands what your policies are. If you're sitting in here and you honestly don't know what your school's policy is on transgender, you should be looking at that. You should know what your school's policies are. They're almost all online now, so take a look at those. Education is very important. Obviously, faculty education is important. Having these types of discussions, you can certainly do a lot with kids. And this isn't necessarily a curriculum. These are those teachable moments that you guys deal with on a daily basis. The community ones are the hardest because it's hard to get the community in. But you don't have to think of it in terms of like educating the community, bringing them all into the auditorium. Doing small things like on a one-to-one basis, inviting them in. If you have those parents that are screaming at each other, and one won't come in when the other one's not in, working with them and trying to get them in so that everybody is on the same page with their child. It can be the same type of thing, that individual teachable moment for the community members as well. Same thing with those school board. A bunch of people, they're really mad and they come to the school board. Obviously there are a lot of ways you can deal with that, but I think reaching out to those people who are really angry. Now, don't do that without your administrations. Don't just go to the people who are yelling at the school board. But those sorts of educational, non-confrontational solutions will help. Developing a system that works, again, one of the biggest things that's going to get schools into trouble is harassment, unlawful harassment, particularly against protected classes. If you don't even have to know which end, which side of the bar transgender students fall under, because the more protective view is if there's alleged harassment, you investigate it. We don't ask whether or not they're protected and there's a law. It crosses our mind as attorneys when we hear stories, but you guys don't think in terms of that. You just deal with it and you make it not happen. But the problem is, make sure that your procedures are in line with each other, that everybody is doing the same thing. Everybody knows if there's a suspicion that there's sexual harassment, that there is disability discrimination, that there's racial discrimination, that there's bullying based on any one of those things. You want to address it again through those teachable moments and as you would address it in any other circumstance, but there should be a formal procedure too. I guarantee you there is a formal procedure. You need to know what that is. You need to know who you go to. You need to know how that investigation starts, and you need to make sure that you're following your policies, because most of the liability happens when individual teachers try and kind of deal with it on their own. The policy on unlawful harassment, that's one of the first ones you should look up, deals with protected classes. It deals with the Title IX and the students with disabilities and race, gender, national origin, religion, those types of things. You have a process for that. You have a policy for that. You have somebody specific in your school that you have to go to. At least I'm hoping that you do, because legally you need to have that process in place. But I've never seen a district that didn't have it. What I deal with all the time, though, are employees that have no idea what the process is. And that's where the breakdown legally happens. So the investigations is fine, but this establishment segment, this is another key area where SAP is really good. Like, you guys can set this example for the rest of the school, because it is about community partnerships and coming up with making those connections to outside resources, both for the school as well as for the students and the families and things like that. So you guys do that on a regular basis. It's kind of who you are and what you do. But schools can benefit wholeheartedly from doing that on a global scale as well. Reviewing the school's protocols, making sure they're working on a regular basis, encouraging that collaboration, and then this is, this last point about the collaboration with other schools. It's exactly what we're doing here, and it's what you do this entire this entire conference. You talk to other people and find out what issues are they facing, how are they solving them, because people have great ideas, and if you share your ideas, you're going to be able to come up with solutions much more quickly than if you're in a vacuum. And I know a lot of you guys are in vacuums because you don't have time to get out of your vacuum, so you only talk to, like some of you, do I have any nurses in here by any chance? You're in a vacuum, right? Like the giantest vacuum of all is the vacuum of the school nurse office. So go say hi to her every once in a while, because like truly, they have no peers. they are the only one in their profession in the entire building, sometimes in the entire district. You operate in a vacuum, so it's really good when you have these types of conferences, and when you can talk to people, ask them these questions. Don't just ask them about lunch. Ask them questions on, is there something that you've been struggling with? Is there a difficulty that you've been having on this or anything else? And find out what they've done or what their school has done, because schools, educators are really creative people, and they're solving things left and right. It's just if we can, kind of coordinate that and get it all together, it will be very helpful. All right, so the next handout that I have for you is everything you need to know about, yes, question?
So are you saying that a school should have transgender policy, even if it's not black and white, but have a policy about how we're going to manage cases? Because we're generally, I'm a parent of a transgender child, and I work in different schools, and generally what I'm hearing is the law is unsettled, so we don't have one.
No, I don't think you should have a transgender policy. If you have somebody who has questions related to gender, related to any type of harassment, if it's a concern that there's something negative going on, definitely you would fall under your harassment policy. But you should absolutely have a procedure, a clear-cut procedure for, look, if I have a question and it's related to my gender, who do I go to? Who starts that process? And it can be as simple as you go to your guidance counselor, the guidance counselor sets up a meeting. It can be as simple as that, where you're going to have a mechanism. You want an outlet for that to be addressed. What we don't want to have happen is for it to bounce all over the school with nobody really knowing how to address the issue. So a lot of schools these days are afraid. They're afraid to step anywhere near a transgender policy, and with good reason, because nobody knows what to put in them. Nobody knows. So they do nothing, and that's the worst thing that we can do. What we need to do is solidify a system and a procedure, and it doesn't have to be specific to transgender though. But if the student feels like they are uncomfortable about something that's going on, or they have a personal issue, anything like that. But certainly, bathroom issues aside, what we all need to be very concerned about is the harassment, the bullying. If it is bullying and harassment that is based on a protected class, it's legally significant and it needs to be addressed through your unlawful harassment policy. So you already have a policy for that set in place. So that type of thing, but not everybody recognizes it as this is the applicable policy. We see it all the time. I used to do a lot of special ed litigation, and we see that a lot in special education. I'm going to talk about truancy in a second, I promise. I really am getting there. But the truancy is another area where we're seeing a lot of cases that are being raised because the students stopped coming to school because of harassment or bullying. That may or may not be true, but at the end of the day, if that's what a parent's attorney can claim, they have a case. So it's important that we deal with the issues head on at the beginning of the process, and that is a great transition into the truancy because I'm going to be talking about that concept a little bit more. All right, so let's look at truancy. In your handouts, what I gave you is everything I'm going to be talking about put into a little, and again, I forgot to save one for myself. I do this all the time. Do we have extras of the truancy one, the back front one? Yeah. Sorry, I should have saved them for myself. I always forget. Thank you. All right, so this is kind of the law in a nutshell in terms of the truancy, and I'll go through some of the procedures. If you want me to stop and go through the procedures more carefully, I definitely can do that, but I think you guys have been inundated with like technically what has to happen. What I am interested in focusing on are those areas of liability if what has to happen doesn't happen. And so I'll fill in the blanks for some of that as well. But same thing, if you have any questions as we go through, definitely let me know. Okay. All right. I'm gonna pass them. All right, so let's take a look at some of the truancy issues. And one of the biggest problems with truancy law is that it literally has no state-by-state comparison. Every single state calls truancy something very different. There are states that after 3 unexcused absences, they start sending them to the magistrate. There are states that don't start sending them to the magistrate until they've had 20 in the same semester. So it is, if you have ever tried to do or looked for nationwide research on truancy in the US, you will not find it because it doesn't exist. It's impossible to come up with because it is such a state-by-state legal issue. So I'm going to be talking about truancy, but I'm also going to be talking about chronic absenteeism. They're very different. Chronic absenteeism is probably much more concerning, but it's also harder to deal with, and I'll talk about that as we go along as well. But when we look at these first statistics, though, maybe we'll look at the statistics, maybe we will not. Let me see. Oh, wait a minute. Oh, my pictures went away. It's really not a big deal, but pictures are important. All right, let me see where my pictures went. All right, talk amongst yourselves. I'm going to get out and go back in and see if my pictures appear again. Okay. I'm not a huge fan of what we're doing, but all the states did it too. Of making attendance an indicator of school success, because by large part, I'm a parent, I have a lot of kids, and honestly, on any given day, I am proud of myself when I get them out of that house. That is an indicator of parent success much more than it is an indicator of school success. But I think with the way that we view it as, so many things are being pushed on the schools, it is a complex problem because of all those different things. All right, so again, national truancy data is really hard to find. I do a webinar on this topic. It was the hardest webinar I ever put together, because you can't really do a legal webinar on truancy, because truancy is a state construct. So what I had to do, and I agreed to the webinar before I realized this. Like I should have thought about it, but I didn't. I had to research every freaking state. I just picked 10 states. I was like, okay, 10 states, we're going to compare and contrast and show how it's difficult. I didn't give you all the nitty gritty, every state and what they do, but it is amazing, the discrepancies. One thing that we definitely know, and this is a University of New Hampshire study, is that guidance counselors are important, but they're also not nearly enough of them. So only 17.8% of school districts meet the American School Counselor Association's recommended student-to-school counselor ratio of 250 to 1. Like, we can't meet 250 to 1, but we're not. The median ratio is 411 to 1. I catch myself all the time because, and you probably heard me say it already a bunch of times, well, the guidance counselor can do this, and the guidance counselor can do that, and the guidance counselor will call, and the guidance counselor will meet with all 411 kids on their caseload, right? But rural districts do have it a little bit better. They're 380 to 1, and they have a little bit higher of a percentage that meet those recommendations. And only 4.2% of city school districts meet or exceed that 250 to 1. That's shameful, because those are the districts that need it most. Access to school counselors vary considerably across the states. Median of 1,000 to 1 in Arizona and California. But then they have 250 to 1 in North Carolina, North Dakota, Vermont, New Hampshire, and Montana. I was in North Dakota last year doing a seminar, and I can tell you why that is. You have to go really far to find 250 kids in North Dakota. Their school districts, every single school district has an average of 100 students, except for Bismarck, which has 1,000. So you go from 100 per school, and I was in there talking about immigration. You get one family of immigrants in there, and now you've got like a legitimate population change in a school district of 100 kids. All right, so, but I do bring that up though, because so many of our solutions, and I think statewide the solutions that are being proposed, even our truancy law, dramatically overestimates the ability and the numbers. Like, nobody is looking at this as a numbers game, and it's easy, I think, politically speaking, to get caught up in let's come up with the best system that's going to hug the children, all of the children all at once. Well, we only have two hands. So when we need, I don't think that there was in this new truancy law enough consideration of the actual practical physical reality of what we're expected to do for each one of these. I in no way disagree with the fundamentals of it, but again, when you're looking at ratios like this, and I don't know where Pennsylvania's is, but I do know that even if it's at 250 to 1, we know how important guidance counselors are on a one-to-one basis with students who have significant needs, whatever those needs are. And even at 250 to 1, that's too much. So it's not getting fixed anytime soon, but I think it's a key point. These are those that we're back to that 2007 juvenile justice statistics, it's always been a fair ratio, male to female, more males. The juvenile justice statistics in terms of the age groups, this is another area where if you have a fascination for statistics and statistical reality, this is a false reality statistic because a lot of states use 16 and 17 as their cutoff. So this looks like kids are magically not truant at ages 16 and 17. Like 17-year-olds have it together and they're just not being absent anymore. That's not what's happening here. We're just not keeping track of them anymore. We're not sending them to the juvenile courts when they're 17 years old. So the statistics are going to look like that. Well, nothing's getting magically resolved. 17-year-olds aren't spontaneously coming back to school in large droves. It's just that a lot of states stop sending them to the juvenile justice system. But if you look at, they're fairly systematic trend lines in terms of race with absenteeism. And then, that kind of stuff is not really important in Pennsylvania because, again, it's not necessarily anything that applies to us. All right, so the truancy versus the chronic absence, the truancy is it's an important issue, but please don't forget about those chronically absent kids. Make sure that, all of the protections and the safeguards and the things that we're giving to these truant kids who are, 6, 7, 8 days absent, those chronically absent kids that have these scripts, provided for them, those are the ones that you really need to focus on if the chronic absenteeism becomes such that it's really going to be very difficult for them to come back, that it's going to be impairing their abilities. What I can say about the chronically absent kids is they almost always become Section 504 issues. When they end up in court, which is more than you would like it to happen, it's in the Section 504 arena because schools have an obligation to accommodate. You guys see some of those goofy scripts where it says, okay, this kid has whatever, they whatever health condition, and they can't come to school, they need homebound. Well, if you talk to that doctor one-on-one, you could probably come up with a schedule. It may be 2 hours, it may be 3 hours. You would do that for that kid. The doctors don't, so they're writing these scripts and just casting away the entire day for that child. So we have to second guess some of those, and not second guess them necessarily, but work with them, because it's not the same as it was 20 years ago. Maybe 20 years ago, if you had really bad headaches, you stayed home all day. Now you guys know we accommodate. We can do a lot for those kids. And so it's important that we don't just forget about the chronic absenteeism because there was a script. I'm not saying that we would ever do something against medical orders. I'm just saying that's the same process and discussion that needs to happen, where we need to get everybody in the same room and talk about, okay, I see this is the medical condition. Let's talk about, is there a way we can keep him or her in for at least a period or two? Like maybe just math, or let's, if it's the academics that's the problem, let's keep him in for lunch so that he doesn't get socially isolated. And there are a lot of things that we can do for that. There's a question in the back.
Yeah. Chronic absenteeism becomes a 504 issue.
Absolutely.
Child chronic issue.
Yes. Yes. In fact, you're like 5 slides ahead of me. So that's the child find issue. That's like the issue of the day. We're now seeing cases where parents' attorneys are bringing cases. This is how good they're getting at their jobs. And it pains me to say that, but it's true. they're bringing cases where the child's been absent. Homebound under the law is 30 days, people. It's not 6 months or a year or wait. That kid is who again? It's 30 days, and then we bring them back in. If you have a longer term absenteeism than 30 days, technically it is a long-term absence, and not only can we not just keep giving them homebound, we actually have to ask the Secretary of the Department of Education if we can allow them to continue staying home. That's what the law says. But schools don't practice like that. We just take the doctor's note and we say, okay, you're out for whatever length of time. Now we're seeing parents' attorneys come back and say, hey, by the way, they were out because there was bullying and he was afraid to come back. Now he's got school phobia, which, by the way, they're arguing is a Section 504 disability, and he's got the school phobia, and you haven't done anything about the bullying. He's afraid to come back. So not only do you have child find liability because you never asked him why he was out, but you also have liability because you caused the disability itself. You see how clever they're getting at what they do. So a couple of years ago, I agreed to be on the Truancy Toolkit Committee at PDE. My sole reason for agreeing to that was because I wanted to build in a child find question in the beginning of the truancy process. How hard is that? Just ask, is this disability related? Let's talk about it. A lot of schools don't want to do that. They definitely don't want to ask about the bullying because they're afraid of what they're going to hear, or they know what they're going to hear. What I'm telling you is, even if you don't ask, it's going to be about bullying. So you might as well ask and investigate it while it's fresh, because 2 years later, they're going to say it was about bullying, and you're not going to have any way to substantiate that. So in your SAIP or in your conferences, ask the uncomfortable questions. Is this a medical issue? And you can talk about that. It doesn't mean that you have to buy it, because you know some of them say yes because they just don't know how to get their, preteen boy out of bed without getting harmed, and that's okay. The more we talk about it, the more solutions we'll come up with. But ask the questions up front, because the child find issues aren't going away. All it does is it makes it impossible to investigate. And many, many times, in fact, I would argue most times, it wasn't there. That's not why, right? I'm a hardcore person. Like, I struggle enough to get my children out of their little beds that I stick it to parents. Like, parent, get your kid out of bed. But if they don't get their kid out of bed and they're not going to school on a regular basis, they can still sue the school district if you didn't ask the right questions and investigate the right things at the beginning. If you can answer those legal complaints by saying, no, there wasn't bullying, we investigated it, here's the report, that's the only way I can win on behalf of one of my schools. So ask those questions. PDE wouldn't put it in. Actually, it wasn't even PDE. I think they probably would have put it in. It was that child welfare. It was CWS at the time. It was DHS. They were the ones that didn't want to put it in there because they don't get sued for child find. There was a question in the back.
Well, I just was wondering, on my school tourism improvement plan, have a section where we do talk about the issues and concerns, what is the problem, and then the next section is what is the solution for the identified problems preventing school attendance. But do you think it would be better if I actually had a checkbox, like, is this related to bullying? Yes or no? Because I have the student and the parent sign the plan. And would it be better for me to have, is this a medical issue? Yes or no?
What would be better for you is do not put the checkbox in there. take notes.
I do take notes.
Because your personal notes can do the same thing as that checkbox would have done, as long as you're taking notes as you go. And if they say yes to the bullying, you investigate it right away. And then you come back and you meet and you go over the investigation report. It's really important to investigate the bullying of the kids that aren't there. All right, and I don't know how you guys decide. Well, I don't know how you guys deal with bullying actually, because like any other day, my kids have a very indistinct, thank you, have a very warped sense of what bullying is. Like, but when they're not attending and somebody is claiming it's because of bullying, that's big. It's a significant legal issue. Bullying is not there's no cause of action against bullying, but it's really, really easy to pull it into something where there is a cause of action, because all you have to do is say that the bullying is related to a protected class. So it's bullying based on disability, bullying based on race, gender, any of those. So be very, very careful, so that you're not getting yourself into trouble. But in terms of documentation, taking those personal notes, that's fine. I mean, I do understand, a school's reticence to have that discussion, and that's certainly fine. But make sure that you know that it's actually a benefit to dealing with it at that point. All right, so all of this stuff that I'm going to go through quickly, it's in your papers, and I think you're already inundated with it. Pennsylvania, in our state plan, we get a couple of freebies. Each state, now it's not like NCLB under the ESSA. Each state gets a couple of categories where we talk about, what types of things does the state feel, indicates school improvements or school achievement. We jumped on the bandwagon like a lot of states and said attendance. So attendance is something that they are going to now be calculating into the school performance scores. Now, it's a very small percentage. It's not the same as, PSSA scores or anything like that. But note that the attendance scores now are going to be part of your school performance score, because Pennsylvania, like many states, chose that as one of the indicators. All right, so we now know that we have two different types of kids. There's truant, there's habitually truant. Truant is the notice, the meeting, the plan, and then the habitually truant, that's when we have to figure out something else. I gave you information, it's all in your papers about what the notice requirement is and that sort of thing. The Student Attendance Improvement Conference has to be held before you go to an MDJ or to CYS. You cannot skip that part. And then parents are not obligated to come to that. But if your parent does not come, you better follow up and figure out why. It could be something as simple as you've got the wrong phone number, email, address. If you are talking to them and they clearly could care less and have expressed to you in no uncertain terms that you can pound salt because they don't care and it's the kid's fault, write all of that down literally word for word. Don't just say, if you've got a parent that's like effing this and effing that, provided that you haven't hung up on them already, write it down in gory detail. Because these magistrates are going to be annoyed, because if we start sending them down to the magistrate without having to do all these processes, we have a lot of processes we have to go through. And so they're going to expect everything to be done, or else we're just throwing work on them. So having it in really, same thing with discipline. It's one thing to say this child was disrespectful. It's a very different thing to say the child went up to his teacher and said, "You are an F." You know what I'm saying? It's a very different thing. And it's the same thing with parents. You can get a very good sense of that, document it, and make sure that you didn't miss something, or that they just didn't know, or they got the date confused. Offer to hold it again if that's the case. Follow up. Don't just say, I did it and I'm done. And again, considering disabilities, and one of my favorite things to do is have my school nurse. Our school nurses can get around the consent law because they are the treating health professional. Under HIPAA, if it's treating health professional to treating health professional, they can communicate to clarify, treatment orders and things like that. So your nurses can talk to the physicians, even if the parents are saying, no, I don't want that to happen. Doesn't mean the physician's gonna talk back, but it's worth a try. And note that your nurses, if the parents won't consent, your nurses are the only ones that can do it. So you have to be, able to, willing to kind of get some more information from that physician. If you're getting a really, the parents are saying, oh, it's this, that, or the other, and you're not seeing any medical documentation, and you all know the issues that I'm talking about. Sometimes it helps. The other thing that we've found that helps a lot is, if you can get parents' permission to confirm with the physician what the parents are actually saying. A lot of times it's miscommunication, whether it's ill-intended or not. There can be some miscommunications that's relatively easy to solve. All right, so the SAIC, the SAIP, this is the hardest part because, again, a lot of this stuff, positive reinforcements, non-disciplinary consequences, family supports, other measures, I feel like if there's something we could have done to get them in, they'd be in there. So we're going to have to work collaboratively. What I can tell you is ask if they're seeing a psychiatrist or they're seeing a psychologist, because one thing that you can do is you can use the same strategies. Right? They're probably teaching them self-help skills. They're probably teaching them coping skills. We can piggyback on that and make that a seamless thing, but we can only do it if they'll share that information. So try and convince them. Again, this is another one of those situations where it's all about that relationship and the meeting. Figuring out what we all can do. The one thing that I did do, and you're so welcome, by the way, is one of the drafts actually had you guys signing off on it like a contract. Like you had to sign off on all these things that were going to happen, such that if the kid didn't come to school, the parents could hold schools accountable because they were on that. So I did insist in a very vocal and somewhat tantrumy way, and they did end up taking that signature line off, so you are also welcome for that. All right. And then there is that habitual truancy menu of options. I know we're running short on time. What time are we at? Okay, so we got 8 minutes left. So what I want to go over with you are the key legal issues, and I have it right here on this page. This discrimination issue, and I say it here again at the bottom of this comparison page, consistent practices are essential. You cannot do different things for different kids. If you do, you are setting yourselves up for a discrimination lawsuit that you may not be able to defend. So, our law gives us this menu of things. If you look at the kids under age 15, we can either refer a child to a school-based or community-based attendance improvement program, which doesn't exist anywhere on the earth. And even if it did, nobody has any money to pay for it. We are seeing third-party providers pop up with them, but they are not cheap. So we've got a problem there, and nobody's using those because they don't exist. That problem is compounded by the fact that our magistrates, you probably never read all the way through because then I would really think you were boring people. But if you read all the way down to the magistrate part of the truancy law, they need to, one of their options is a community, it's literally the same terminology, a community-based attendance improvement program. So if there is one in your community, now you're fighting with your magistrate over it. And if you both use the same one, well, that's just dumb because you're going to put them through it and then the magistrate's going to put them through it and it's the same one. And if it worked the first time, we wouldn't be putting them through it again. So the school and community-based attendance improvement programs, we don't really have a model yet. And so that's really complex. I'm working with a number of other individuals, including PSBA, PDE, PASSA. We're trying to explore, anybody from York City School? Which school do you teach at? You're where?
York County, but not.
You're York County. So York City School has been using youth courts for truancy prevention, and they went from being like the 6th worst in the state for attendance to being up in, I think they're in the top 10 now. They've been doing it for about 10 years, and so we are looking into the potential of using youth courts for as a mechanism for this, because it's cheap, it's easy. You've got your little jurors all there, you know. So it's something that we could open on a statewide model. So we're exploring that, and we're kind of working with that. This is another one of those areas. If you have a program that's good, that works, that you can do internally, share that, because nobody has a solution. The other option is referring them to CYS, but CYS literally under the law. Who are my county agency people here, right? Anybody here who can vouch for me on this one, right? You literally can't do anything about attendance, right? Under the law, they literally have to bounce it back. There's nothing they can do. Now, truancy can fit the definition of neglect under the Child Protective Services law. Nobody's ever going to do that because no prosecutor's ever going to take that case. So they are looking at it from the perspective of, is this a taking the child out of the home situation? And it never is going to be. So CYS is not a good option.
So I have a couple of things. Allegheny County does have a community-based truancy prevention program. It's called
Okay.
Some Attendance, and they'll be here on Tuesday to present for about an hour.
Does anybody use them? Is it a good program?
All the time.
Which county is it, did you say?
Allegheny County.
Is it the same one that their magistrates use?
Well, they have a representative from Focus that comes to the magistrate hearings, and they're available for parents. And so our magistrate will offer it as an alternative. They'll kind of put it on hold, the citation on hold, if the family is agreeable. Because Focus on Attendance is a voluntary participation. And basically what it is there were so many CYF cases being opened because of truancy that they wanted to find a way to be able to refer families to these family-based agencies that come in and deal with the family system without having to activate them with the court system.
Right.
Focus started, and that's like a third-party referral system to these agencies that used to only be available for CYF caseworkers.
Right, right.
So that has worked, I'd say, for me. I'm in a high school of 1,500 kids, so for me, it's probably worked with like 7% of my students because I'll sit in a meeting and I'll say, listen, your attendance is improving. We have two choices. I can refer you to this agency. They'll come in, they'll work with you, they'll work with the kid, work with parents. It's voluntary, or I'll send you to the magistrate. So they say, sure, I'll do the community-based thing. I do referral. They spend 2 weeks trying to get the family to call them back. The family doesn't
Right.
call them back. And then they call me and say, sorry, the family didn't call me back, it's closed. And now the family about 3 weeks out of court without filing a citation anyway. But for the ones that have agreed and followed through, it has been successful. The other thing I wanted to say is CYF will not file a dependencies petition due to truancy, but I can. And my local police department can as well. And so
Wait, who are you? What's your role?
I'm a social worker
In the school.
in the school.
Okay.
In Allegheny
But they're not gonna, the courts probably are not gonna go through with that just based on truancy, if it's just truancy.
Well, I mean, basically, no truancy is just truancy. So
Right.
it's a lot of involvement investigation, and I have to make a pretty severe case, but I've had success with like most chronic truancy kids. I've had plenty of them. I mean, I'd say maybe 3 or 4 a year. We found dependent and get court order to have treatment or drug and alcohol treatment. I mean, it's a lot
Right.
of work, but it does.
Well, so guys, this is one of those areas, go to that session and talk to each other. We need solutions. I'm gonna give you the quick and dirty thing that will work. It's not going to solve the problem, and it's not going to like be the educational or a solution you need. What you need to do is you need to take these options, CYS and dependency action. All right, I just told you they're not usually going to take a kid out of the home, but draft the scariest, most terrifyingly descriptive letter you can think of that describes the magistrates, that describes the fact that they can get jail time. We all know they're not getting jail time, but they could. So come up with documentation that sounds so terrifying they're afraid to not send their kid back to school. And you don't have to lie, because it's all in there. You are sending them to CYS for consideration of a dependency action. If there's a dependency action, they get their kids taken off of them and they may get prosecuted for child abuse. If they go to the magistrate, it's what's the fine now? Like $2,500 plus up to 3 days in jail. And the kid, by the way, the kid, if they're of age, can lose their driver's license. That's all you have to tell them. They don't want to lose their driver's license. So at this point, until we come up with workable solutions, talk to each other about things that are working, things that are developing, or things that are already developed. And in the meantime, come up with those really descriptive, one of the things that always came up in my child abuse trainings is people would always say, what about a parent that doesn't make their kid wear a seatbelt? Is that child abuse? Is it not child abuse? Well, I don't even know what the answer to that is, but I do know that the 3 counties near me all have a seatbelt letter that would make me afraid to not put a seatbelt on my kid. So sometimes it's about, sometimes you have to come up with those workable solutions until we can get a little bit more. Like, I think this law came a little bit prematurely. We needed the supports in place before we could do it, but we don't have them. We're stuck with it. So I am telling you though that can be very effective, if you change the language a little bit. I give you some other pointers and tips on here about if you have, an abusive, lots of people abusing this excuses, things to be talking to doctors about if you can get them to talk to you. And then I also have, the one thing I want to point out before we're finished is this one right here, the new burden on schools for MDJ proceedings. I haven't heard a lot about this in a lot of the summaries, but if you ask me what is the most significant change in the law, like what's the most legally significant one that's potentially going to backfire on schools, it's this, because